Welcome to Legal Studies, and today we're going to be learning about the purpose and appropriateness of Vcat, the Victorian Civil Administrative Tribunal. So where are we in the study design? Here we are, right here. You'll have just finished thinking about the factors to consider before you sue someone, and that's really all about the what. What should I think about before I sue someone? And this dot point here is really all about the where. If I'm deciding whether or not to sue someone, what are my alternatives? Where else could I go? And one of your options is Vcat, and we're going to learn about that today. So here we go, the Victorian Civil Administrative Tribunal. What's its purpose? Well, Vcat aims to provide a low-cost, accessible, efficient, and independent tribunal. So it's an alternative to going to court. Rather than going to court, you could go to Vcat to have your civil dispute heard. And it tends to be cheaper, it tends to be faster, it tends to be a lot more flexible and less formal than going to court. So what's its jurisdiction? In other words, what type of cases can it hear? Well, Vcat hears a huge range of cases. It hears a really broad variety of things, ranging from administrative cases, such as about planning and environment. So let's say perhaps there's a 3-story house being built on your street, or an 8-story apartment complex, and all of the neighbours on that street think it's violating the council's planning regulations. You could take that builder to Vcat and have them modify the designs of the building, perhaps. It also hears a really broad range of disputes in its civil list, including, really importantly, they hear a whole bunch of consumer matters. So if you've got a dispute between, let's say you've purchased a product and it's faulty, and you've got a dispute with the manufacturer, you could take that to Vcat. Or if you hired someone to perform a service for you, you could, if you feel like they didn't do a good job, you could take them to Vcat. They also hear residential tenancy issues. So when there are disputes between landlords and tenants about their lease or about the property, the treatment of the property, return of the bond, and things like that, these are all disputes that can be heard by Vcat. So they hear a really huge variety of things. How do they try and help? What do they do? Well, they primarily use 3 different types of methods to resolve their disputes. First of all, you could go to Vcat and get mediation. So there is an option, particularly if you're hearing, if you've got a consumer dispute about goods and services that are relatively cheap, less than $10,000, there's an option for a fast-track mediation process. So Vcat can offer mediation. They also offer what they call compulsory conferences, which is similar to conciliation. And there you can go and have a Vcat conciliator hear both parties, hear what their issues are, help them find solutions and resolve their issue together. And finally, you can also choose to have what's called a final hearing, which is a little bit like arbitration. That's where both parties present their case to the Vcat member, the Vcat member listens and then makes a binding decision on them. So the key part of this study design dot point that you need to be able to answer is, when should I make the choice to go to Vcat? When should I choose Vcat instead of court, or instead of the other options I've got in front of me? So when will Vcat be appropriate to use? Well, first of all, when it's within Vcat's jurisdiction. Or in other words, when it's a type of case that Vcat can actually hear, such as a consumer dispute or a residential tenancy dispute. It's appropriate to go to Vcat if you're looking for a low-cost option, as most of the lists in Vcat either have low or no hearing fees, so cheaper than going to court. It's less formal than going to court, and therefore potentially less stressful for people. 80% of cases that go to Vcat are self-represented, so no lawyers involved, and that's another factor that can make it cheaper for people, a reason why you might want to choose Vcat. And it can offer binding decisions in their final hearing process. So if you go to Vcat, you can get a final binding decision. And it also offers you real flexibility in terms of the types of dispute resolution processes that are available to you. So there are a lot of really good reasons you might want to go to Vcat. But when might you choose not to go to Vcat? When would it not be appropriate? Well, for example, if it's a type of dispute that Vcat can't hear, for example, a class action, Vcat won't help you. Disputes between an employer and an employee, not within Vcat's jurisdiction. They won't help you. Same thing with disputes between neighbors. Vcat won't help you with that. You should also probably not choose Vcat if you want to leave the option open to appeal the case. So if you think that you might want to appeal it further, Vcat's not a good option for you because appeals from Vcat are really limited. You can only appeal if you think they got the law wrong. You might choose not to go to Vcat if you think the formality of court would be beneficial for you. Perhaps you think there's a power imbalance between you and the other person. You're a little bit worried or scared of them. Perhaps that real formality of court might help you actually feel more comfortable. And if you want the court to make a legal precedent, in other words, make a decision, make that decision public, and make sure that every case in the future has to follow that same reasoning, then you'd have to go to court to get that, because Vcat decisions don't create precedent. So there's a whole range of situations when Vcat will be appropriate and a whole range of situations when Vcat's not going to be the best choice. And that's the main thing you're going to need to think about when you're doing exam questions on this topic. All right, that's it from me. See you next time.